Mr. Fabiano?
May it please the Court.
Good morning.
Jack Fabiano, Wilmer, Cutler, Pickering, Hale, and Dorr, on behalf of the appellant Craig Breakiron. This is a matter on reservation and report from the Land Court. None of the defendants, including the Internal Revenue Service, have filed an appearance or otherwise answered in the Land Court or in the Appeals Court or in this Court. And in fact, the IRS has notified this Court by letter of July 29th that it does not intend to appear or file a brief. Because the matter is unopposed, I'll be very brief and I'll answer any questions the Court might have. The appellant seeks the reformation and rescission of 2 disclaimers of interest in real property, registered land on Nantucket. The disclaimers are part of the record at pages 29 and 32.
Mr. Fabiano, is the Connecticut attorney still alive?
Yes, Your
Is
Honor.
there a
So
reason
far as
that,
I know.
Is there a reason that there's no affidavit or any information from him or her?
No, Your Honor, I have no reason. I do have an affidavit which was never filed from Mr. Breakiron himself, testifying as to what he did, what his reasons were for executing, although I think those reasons are apparent on the face of the disclaimer. The disclaimer itself says that it's for purposes of being a qualified disclaimer under Section 2518. It recites several of the factors, saying that he has not received any benefit from the land, and it even recites the 9-month window, although it cites it for the wrong purpose, with the wrong interpretation. I think that if there had been an appearance filed below, we would have filed an affidavit which would do nothing more than reiterate the purposes that are stated in the disclaimers themselves.
Sorry, one more question.
Sure.
Why below was since there was no answer or appearance or anything, why wasn't the other parties defaulted? Why weren't they defaulted?
Your Honor, the court below granted the motion to reserve and report. As I read Commissioner versus the estate of Bosch, and I think as
that may apply to the IRS, but the other parties.
Well, I have no answer to that, Your Honor. My concern was the rest of the parties are family members who were all part of this attempt to avoid gift tax.
That's partly why I'm a little concerned.
Is there any statement of agreed facts?
No, Your Honor. There's merely a complaint, and then there is an entry of an order below reserving and reporting the case to this court or to the appeals court, and then we filed a petition for direct appellate review by this court.
And it's not a verified complaint?
It is not a verified complaint, Your Honor. If Your Honors are troubled by the fact that there is no affidavit, I have the affidavit. I would move for leave to file it at this point and serve the other parties. But I do think on the basis of the disclaimers themselves, the facts are apparent that the only purpose for executing these disclaimers was to avoid federal gift tax, or at least to defer a portion of the federal gift tax. And that being so, because these were executed on the basis of erroneous legal advice, rather than deferring or avoiding gift tax, they in fact triggered a gift tax of about $2.3 million.
I take it the trust instruments themselves haven't been filed. The trust instruments themselves haven't been filed, correct?
They have not, Your Honor.
So we don't know whether there are any minor, unborn, unascertained, or incompetent beneficiaries. I mean, essentially the challenge here, I think, Mr. Fabiano, is that what this court does from time to time, and we have done for a long time, we do when there's a full record where we can actually tell by affidavit, by sworn complaint, by looking at the trust instruments themselves. I mean, essentially what we have is an unsworn allegation. We don't have the trust instruments. I mean, I'm not questioning your bona fides. I'm just saying, you know, from the court's point of view, we have to have a record that we can really look at to make sure that we are not inadvertently entering an order that appeared to be fine, but actually there was a whole other set of circumstances that if somebody had asked.
Well, as I say, I have with me the affidavit. With leave, I would file it. I think it merely recites the facts that are set forth in the complaint, but it is under oath.
And then what about the trust instruments themselves? Are there any other beneficiaries? I mean, how do we know that there are no other beneficiaries?
Well, Your Honor, if the court grants the relief requested, you won't be undoing the trust instrument. You'll only be reforming and rescinding the disclaimer. The trust instruments would remain in effect. I
Right.
seek no relief with regard to the trust instruments.
Right.
So that if that is so, we're simply back to where we were for 10 years after the trust instruments were executed. They remain in effect, and Mr. Breakiron would remain a beneficiary of those trust instruments, and he would then have to deal, and the property would pass him under has already passed him under the trust instruments. I'm not asking for any action that would affect the rights of any of the beneficiaries of the trust. I'm simply asking that his own ill-advised action based upon the instructions of counsel be undone, and we won't touch the trust instruments by doing that.
But in theory, right, if there was no, aside from the gift tax problem, if there was no relief, there may be beneficiaries of his, is it his sister? Is that who he gave it to?
Yes, he and his sister are co-tenants, or tenants in common under the trust.
So the relief you're seeking will leave him as a co-tenant, correct?
It will leave him as a tenant in common, but, yes, that's right. It would put him back to the position of being a tenant in common with his sister.
But the action that he took in 2006.
Was to make his sister the sole tenant.
Right. So there may, so I think.
So they may be her children.
That's right. There may be people affected by it, quite apart from the tax issues.
I mean, he may not, there may be consequences when you get bad legal advice, but we have to be very careful before we undo them. Let's assume that she has children.
Yes, Your Honor. An assumption I can
Oh,
neither confirm or deny.
an easier one is a spouse.
Yes.
Probably because they, you know, well, they are, I mean, don't we have to take into account whether the spouse of the sister wants this undone?
Wouldn't, Your Honor, wouldn't the fact that she failed to appear, and although no default was formally entered, wouldn't that bind her to the facts of the complaint?
It might bind her, but would it bind her spouse? That's, don't know.
Well, I don't know whether she'd whether her spouse would stand in the shoes. I mean, if that were the case, Your Honor, it would seem to me that in every case, even cases that don't involve trust instruments, if there are potential for a relative.
No, but with the, you know, yeah, I understand. I mean,
that in each of those instances, you would need to get, you know, some sort of notice that, or have a guardian ad litem appointed for any purpose.
Yeah, we often do.
If the court is troubled by that, I mean, we could have a guardian ad litem appointed, or I could obtain from, I certainly don't mind filing the trust instrument, so I think that's not quite on the point. I think that, I suppose, I'm not sure how I would respond to the court's inquiry. If I go back to the sister and say, would you give me an affidavit that says that you have children, does she then have to get a guardian ad litem appointed for her children?
Let me put it this way. You have tenants in common, and the person who, gives the, grants the property, whatever the word I'm looking for.
The disclaimer, Your Honor, or the?
Yes. When that happens, certain rights, that now belongs to the sister.
Yes, Your Honor.
The mere fact that she didn't answer often is not sufficient, because I don't know what that means. But that act may have given rise to rights of people other than the sister.
Well, Your Honor, it may, but there's nothing to indicate that. If she simply did not answer, or if she filed an answer below saying, I admit all of the allegations, would it have been necessary in that instance to obtain things from her maybe children or husband?
I don't know.
I think not. I think that the fact that none of those people have rights except as they may derive them from her under her estate plan or under something that she does in the future, or some gift she makes to them. If she forfeits her rights by failing to answer in the land court, then I don't think that I'm under any requirement to go beyond that to find out whether there's a possibility that some other party might be impacted by that. If we were to go back to the original trust instrument somehow, I see how that would be a concern. But I'm not doing that. I'm simply undoing the disclaimer that he made that gifted this property to his sister.
Okay.
Okay.
Thank
Thank you, Your Honor. Thank you.